All right. A very good evening, afternoon, and morning, as the case may be to one and all. I'm really delighted to be here to see so many of my friends from all over the globe. In particular, I'm so pleased to be amongst my friends from India, many of whom I've not seen for a long time, in no small measure due to the pandemic, which continues to plague all of us. The program this evening, has been in the works for quite a while. However, thanks to the energy, drive, and vigor of Sumant, Cyril, and Biram, stalwarts of the III fraternity in India, and of course the support of my friend Dr. Sahoo, an outstanding program has been curated. I should also acknowledge the contributions of Evan Zucker and Annika Wolf from the III. India is an important jurisdiction in so many ways, not only for Asia, but also for the world. In insolvency, India has certainly caught the eye with her bold, innovative, and ambitious reform agenda, which I'm given to understand still has some distance to run. The International Insolvency Institute has been watching developments in India with keen interest. The III is committed to increasing its engagement with India. We hope to do this by working closely with India and our insolvency fraternity in areas of importance to India's reform agenda. The program this evening is just the first step, and there are already discussions underway on some significant new initiatives. While my friends from India will know best, I offer for consideration 4 areas for potential collaboration. First, facilitating the development of a framework or set of principles for out-of-court restructurings. I suggest that this is an area that requires attention. Second, studying the use of ADR, in particular insolvency mediation, in plan building and the resolution of issues in a restructuring, in particular the cross-border variety. Third, facilitating the development and growth of a distressed asset market in India. And finally, working with partners in India to develop a masterclass certification program for insolvency practitioners in India. Of course, if there is take-up for the ideas that I've offered for consideration, the details will have to be fleshed out. But I do not see that as an issue with the wealth of talent in India and the strength of the III's commitment to India. So with these brief words, I shall leave you in the good hands of Dr. Sahoo and Sumant. I very much look forward to Dr. Sahoo's keynote address and the session that is to follow, as well as interactions that I'm sure we will have. Thank you very much.
Well, thanks so much, Justice Kannan. We have always known you as a great friend of India, not just in terms of the personal relationship that you have with many here, including with me, and also your keenness to see India roll forward on the insolvency stage. And I know that you've been very forthcoming in providing us your guidance, support in more than one ways. And I'm glad that now, wearing the III hat, that you renew that offer, and the 4 things that you listed are certainly something which are very much on the radar for the in policymakers in the Indian market. Dr. Sahoo might want to touch upon them as well in his comments. In particular, some of them, like the ADR, is something which we see as a next generation reform, but something that we've been thinking of already for quite some time. And I can clearly say that in the 4 years, what we have achieved in terms of implementing the insolvency law so effectively, and of course there was some disruption like anywhere else on the account of COVID. We have been adopting measures to stabilize and bring everything back on track. But while that exercise is on, the policymakers stay alert to the developments that are taking around the world, and those that are next generation reforms which should not get off the radar. And that's why I'm glad that you mentioned the 4 things. And distressed asset market is something, and we see this as something which is an offer that we'd like to grab, and we will certainly discuss and distill with you an agenda to take them forward. Now, with these, and again, once again, thank you so much for taking the time out. I know it's very late for you there. but I know your enthusiasm doesn't die with the hours of the day, knowing you from the degree of energy that you hold. The panelists are, stalwarts in their own rights, in their jurisdictions across the borders. I don't even need to introduce them, and I think their name speaks for their experience, their profile, and some of them. Jamie has, he's been a very old colleague at Insol International. We go a long way back, and his excitement for Indian market is just unbelievable. Not only does he not forget to remind me, to wish me on my birthday or anything, but it's also, he doesn't miss any development that happens in India. I will get an email from him. I just heard this. If there's anything I can do, it's just unbelievable. Hats off to you, Jamie. I hope you still have those 5 or 7 phones that you constantly keep with you. and you do, yes, I'm sure. And how do you juggle all of them? Yeah, it's always been a mystery. But let me just come back to the topic of the day, something which is of keen interest to the Indian market. We have been waiting for quite some time to believe that we are ready, and so that we could actually take it upon ourselves as the Indian market to look at the pre-packaged schemes as well, while the insolvency law is on its track. And some of you, for the benefit of those who might not be aware, that there has been almost a permanent insolvency law committee which has been guiding the government in its reforms agenda. And that insolvency law committee comprises of a number of eminent experts and from diverse fields. And they had constituted a subcommittee, which Dr. Sahoo was chairing, to recommend a framework for pre-packaged schemes. And that report was submitted some time back, and it was submitted for public comments. And I believe the comments that have been received so far are being considered by the subcommittee and of course IBPI, which Dr. Sahoo heads, as well as the government. And this particular workshop, I'm quite sure, the seminar, the discussion, the roundtable, will certainly provide us some very deep insights on how this has worked in jurisdictions, in particular US and UK, from which we believe we have a number of experiences to take back from in terms of applying it in the Indian jurisdiction. Of course, tweaking them as appropriately in the Indian context. Every market works on its own dynamics, and India is not different in that sense. So at this point in time, I would turn to Dr. Sahoo, who is the chairperson of the Insolvency and Bankruptcy Board of India, who's a regulator of insolvency professionals, well-versed, and also his board is responsible for framing the regulations for the corporate insolvency resolution process, the liquidation process, the individual insolvency process, bankruptcy process, and the fast track and the evaluations. And he's done a remarkable job. He's been the flag bearer, the champion. I just would fall short of adjectives in terms of the effort that he has made in order to create an unprecedented track record of implementation of any law so far in the history of India. And look forward to hearing from him on his views on pre-pack and generally. And then I'm sure he and his colleagues who are tuned in would also be waiting for our discussion going forward. Over to you, Dr. Sahoo.
Thank you, Mr. Batra, for the generous introduction. Honorable Justice, distinguished panelists, friends, ladies and gentlemen. Thanks to the III International Insolvency Institute for this opportunity to join you today in a discussion on something which every stakeholder of Indian insolvency regime is passionate about. This is the proposed pre-pack framework for insolvency resolution, which is envisaged as a consensual liquidation remote framework, as a hybrid framework having an element of informality, but the sanctity and advantages of a formal process, which we consider a natural step in the evolution of insolvency regime in India, It has been proposed within the discipline of the Insolvency and Bankruptcy Code, and if introduced, this would take Indian insolvency journey to the next level. I thank III for its interest in and engagement with Indian insolvency regime and the proposed pre-pack framework, and I am sure the policymakers in India would greatly benefit from today's discourse. We also gladly welcome III's fourfold offer. On all four folds, on four dimensions, the work has begun in India, and we will be definitely seeking your help and guidance in these four matters. Let me briefly touch upon the Indian insolvency journey. It began about 4 years ago. It has been nothing short of remarkable. The entire ecosystem and the regulatory framework were put in place very swiftly, enabling commencement of a corporate insolvency proceedings within 6 months of the enactment of the code. The years since then has witnessed an unprecedented cooperation and partnership among the authorities and stakeholders, which made this journey purposive. The journey on its way encountered several challenges. It took them in its stride. It made prompt course corrections to suit evolving requirements. 5 amendments to the code in about 4 years and dozens of subordinate legislations are testimony to the dynamism of the journey and the commitment of the government to the underlying reform. Almost every provision in the code and all the 5 amendments to the code have gone through intense judicial scrutiny. The courts have generally considered freedom to experiment to the legislature. The code, as well as every of the 5 amendments, have passed the constitutional muster. The adjudicating authority, the appellate authority, the high courts, and the apex court in the country have delivered several landmark orders to explain conceptual issues, settle contentious issues, and resolve gray areas with alacrity. Today, insolvency law boasts of probably the largest body of case laws. The code has established the supremacy of markets. Insolvency being an outcome of market forces, the code enables market to find a solution. The early harvest has been extremely good, from providing freedom of exit to rescuing companies in stress, to helping creditors to realize their dues, and most importantly, bringing about a behavioral change among the debtors and creditors while reinforcing the rule of law. The list of achievements of the code is long. India's rank moved from 136 to 52 in terms of resolving insolvency in the last 3 years in the World Bank Group's Doing Business reports. A recent study by Professor Bose et al. Published in the latest issue of the Journal of Corporate Finance finds that IBC has been instrumental in enhancing the availability of credit at a lower cost for financially distressed firms. The code has emerged stronger as it delivered on its promise, passed the constitutional muster, earned global recognition, and has become a preferred option of the stakeholders in case of default. As the insolvency journey was picking up steam, the COVID-19 pandemic struck the world. The unparalleled misery required a matching response to save lives. That required saving livelihood, in turn required saving lives of farms. As an immediate measure, government enhanced the threshold default for initiating insolvency proceedings to insulate MSMEs who were worst hit by COVID-19 from being pushed into insolvency proceedings. The code enables the market forces to pursue 2 complementary remedies in respect of a failing firm: rescue a viable firm and liquidate an unviable one. It searches for a savior to rescue a failing firm when every firm, every industry, and every economy is reeling under stress. the likelihood of finding a rescuer for a failing firm is remote. If all failing firms were to undergo insolvency proceedings, most of them may end up with liquidation for want of saviors. And rescuing lives of firms being the prime objective of the code, it could not have been used to take away their lives prematurely at these unusual times. The unprecedented situation called for a choice between two competing policy options, namely suspend the operations of the code or continue its operations as usual. If the code is suspended, the market would fail to liquidate an unviable firm. This is not good for an economy, but this can be rectified in the following quarter. But if the code is not suspended, the market may liquidate a viable firm forever, which can never be undone. Rescuing a viable firm being far more important than failing to liquidate an unviable firm, the choice fell on suspension, which provided breathing time for the firms. Again, the suspension has two further sub-options. Suspend the code in entirety or suspend some elements as may be necessary. The suspension in entirety would not allow liquidation of a failing firm, whether it was unviable before COVID-19 or became unviable on account of it. It would also not allow rescue of a failing firm even if it were viable before the COVID-19. The policy should protect those firms which are victims of pandemic and not protect the undeserving. The choice therefore fell on suspension of only such provisions of the code, unlike probably every other jurisdiction, that the code should be suspended for such purposes and for such period as are necessary under the circumstances, avoiding any unintended consequences. Accordingly, an amendment to the code prohibited initiation of insolvency proceedings in respect of defaults arising during 1 year, commencing the first day of a nationwide lockdown in India. The code envisaged standard plain vanilla process to start with, but anticipated sophisticated options with the maturity of the ecosystem. With considerable learning and maturity of the ecosystem and a reasonably fair debtor-creditor relationship in place, the ground seems ready to experiment new options for resolution of stress under the code. Today, there are two court-supervised statutory options. One we call CIRP, Corporate Insolvency Resolution Process under the code. Another is a scheme of compromise and arrangement under the company law. And there's one out of the court option under the central bank's prudential framework for resolution of stressed assets. These frameworks provide a guided path for resolution, define the role of stakeholders therein, confer certain rights and benefits. CIRP confers advantages and privileges like moratorium during resolution, binding nature of resolution plan, clean slate post-resolution, several regulatory benefits which are not available in case of other options. These are available under the code. This makes the CIRP the most preferred option. However, as I just mentioned, CIRP has certain difficulties at this hour. It is not available in respect of all defaults, such as defaults arising during COVID-19 period or defaults below ₹1 crore, Indian rupees 1 crore. 10 million, and the availability of resolution applicants, which is critical for CIRP, is a concern in the wake of COVID-19. So this has two consequences: either the company remains under stress for too long without any resolution, or creditor uses every means to recover their duties. In either case, the company may not be able to survive. A formal framework has a set process and therefore some amount of rigidities, while market prefers flexibility to work out a tailor-made resolution best suited to the circumstances. The market wishes to have the regulatory benefits but does not like a completely unguided path. These call for a semi-formal option which sidesteps the difficulties of formal CIRP, has an element of informality, but sanctity and advantages of formal process. In a sense, formal framework and informal frameworks are two ends of the spectrum, and a variety of hybrid structures possible that blend elements from both the types of frameworks. These are available internationally to meet the convenience of stakeholders, and the most popular form of this is the semi-formal option, pre-pack. The insolvency laws around the world provide a variant of pre-pack in addition to regular resolution process. Pre-pack has emerged as an innovative corporate rescue method that incorporates the virtues of out of the court and in the court insolvency proceedings. It's a preferred option as it empowers stakeholders to resolve stress as a going concern with minimum assistance of state, particularly the adjudicating authority, which is overloaded in Indian context. It is considered fast, cost-efficient, effective, with least business disruptions and stigma attached with formal processes, starts with an informal understanding, engages the stakeholders in between, ends with a judicial basing of the outcome, though the nuances can be different across the jurisdictions. Pre-pack, we are aware that has its share of concerns like serial pre-packing, where controlling parties buy the company successively to avoid debt rather than rescue the company, and lack of transparency. The private negotiations and understanding among a set of stakeholders which contributes to the advantage of pre-pack is often a source of concern. To address such concern, pre-pack, though emanated as an informal practice in the market, is becoming more formal and acquiring some regulations. All these have some lessons for Indian context. So with the likelihood of increase in insolvency as suspension on initiation of a CRP expires on 24th March 2021, when formal frameworks are not very effective in the wake of COVID-19, particularly because resolution applicants may not be available, coupled with the limited adjudication ability, capacity of the adjudicating authority, and more importantly, given that some of the existing frameworks, the CRP or the central bank's prudential framework, they already have an element of pre-pack, and ground is ready in terms of improved debtor-creditor relationship and matured ecosystem. Time seems opportune to introduce pre-pack in India with appropriate checks and balances. The thinking is that it should be within the basic structure of the code, like financial creditors who will have extensive control. It will still be creditor in control, but debtor in possession, unlike resolution professional taking over possession. CD, the corporate debtor will enjoy moratorium, outcome will be binding. So it must imbibe all those features which make a CIRP sacrosanct, and therefore it can enjoy the benefits, privileges associated with the CIRP. And it will also have inbuilt immunity to prevent any potential misuse. The budget, the union budget presented on 1st February 2021 has proposed alternate methods of resolution, which of course includes the pre-pack. A subcommittee had submitted a draft structure under consideration of the Insolvency Law Committee, and thereafter, after due process, it requires an amendment to the code, and possibly if the things fall in place, this could be considered in the ongoing session of the Parliament. The budget also proposes a few other things like a special framework for MSMEs. We acknowledge that MSMEs are different from other companies in many ways for the purpose of resolution. MSMEs generally have loans from informal sources which do not have access to resolution frameworks as available to banks. Many of them do not have stamina to sustain a full-fledged CRP style of resolution. The value of an MSME often lies in informal arrangements, making it difficult for a third party to harness value through a resolution plan. The market for resolution of an MSME firm is local. In recognition of these unique features of MSME, a special framework tailor-made for resolution of MSMEs is under consideration. Also under consideration is strengthening of NCLT, the adjudicating authority, and implementation of e-court system to faster resolution of the cases. Considerable work has happened in the areas such as cross-border insolvency, group insolvency, fresh start process. The personal insolvency in respect of guarantors to corporate debtors is already in place, though there are some issues which is still engaging the attention of the Supreme Court, the highest court of the country. As Mr. Batra mentioned, the work has begun on institutional framework for valuation profession, because we realize that an inappropriate valuation, if we have an inappropriate valuation, it is possible that the market closes a viable company or rescues an unviable company, both of which are detrimental not only to the stakeholders but to the economy. And therefore the work is on to provide a complete institutional framework. Indian regime is focused on the rescue of a company in stress. The success of a rescue operation depends on how resolvable the company is. The likelihood of resolution is more if the company has value, and such value is free from encumbrances, is visible to a discerning eye, easily realizable by any resolution applicant. It is less if value resides in informal off-the-record arrangements or personal relationship of promoters, disputed titles, complicated structures, contingent contracts, or in avoidance transaction. To improve the likelihood of resolution, the market has started talking about having a sort of living will that provides a guided path for resolution. Resolvability, reflecting the readiness of a company to implement rescue strategies in a swift manner, is imperative as the intensity of competition and innovation increases in the economy. So it is not that the reforms are coming only from the state. The market is also getting ready, preparing itself to get advantages of the emerging features of the insolvency regime. Several other initiatives are in pipeline. These are all available in press, in websites of IBBI, government. But there is a determination to actualize those initiatives at the earliest. With this, I conclude my talk. Thank the III for giving me this opportunity and reiterate that we would be seeking your guidance on all those 4 matters. Thank you.
Thank you so much, Dr. Sahoo. I know that it's also late for you, but again, like I mentioned for Justice Kannan Ramesh, I mean, I've seen you work around the clock, so I knew that you wouldn't complain for the late hour that we are in. You know, as Dr. Sahoo mentioned, that we do have pre-packs that exist around the world in variant forms, and India has. At this point in time in its thought process, propose something which they consider would be most suitable for the Indian market. And as Dr. Sahoo mentioned, something which sort of is being fit into the basic structure and framework of the existing code, more as a formal framework, operating in the shadow of the code, but not as hands-on as the CIP, formal CIP processes would be. And I think, therefore, it won't really be surprising if I were to ask the first question is a very elementary question in terms of trying to get to understand from the panelists that represent the 2 jurisdictions in terms of how do they understand pre-pack in their jurisdiction. Let me start with you, Jamie, on that. And I am also going to ask you a supplementary question, which you could also add a comment on. That is it, in whatever form pre-pack operates in US, does it operate alike in all the jurisdictions, or within the various jurisdictions in US it also functions in different avatars?
Let me answer the question, but thanks. First, thanks for having me, and a pleasure to address all the folks in India, and appreciate you doing this on your nighttime, and people from around the world. So interestingly, in the US, while pre-packs are quite relevant, quite prevalent, and the term is used all the time, it is nowhere defined, and it doesn't even exist in our statute. And so it's become a de facto rather than a de jure term of art. But it has a variety of meanings, and I'll go quickly, but a true pre-pack, which we call a prepackaged plan, means that the vote on the plan happened before the bankruptcy case was ever filed in the United States. And if you're a public company, that means you have to, in order to do that vote, you need to comply with whatever the applicable securities laws are. If you're not a public company, a private company, the securities laws may not come in. And more broadly, what it really means is you need to have extensive disclosure as to what you're doing. You need the plan of reorganization and then the disclosure statement that describes everything. And that would be the substance. And then procedurally, you need to give broad notice to all of what we'll call the parties in interest, which is a defined term. But figuring out who all those people are is a job, because usually if it's going through a bankruptcy court and it's not prepackaged, a judge would sign an order that says, here's all the people that need to get notice. So the burden is on the debtor to make sure you get notice out to all of the right people, because you don't have a judge pre-approving both the form, the content, and the recipients of the notice. Now that's the prepackaged plan. Now we also have something we call the prearranged plan, and that's even more prevalent than the prepackaged plan, because often a debtor does not have enough time to do the vote out of court. I think we're going to talk how long it takes in a little bit, but it takes longer to get the vote out of court. So often we have what's called prearranged, and what that means is there's basically a deal amongst all the important parties, and maybe we have what's called an RSA, or restructuring support agreement, maybe we don't, but the most important parties, stakeholders, creditors are on board, at least the ones who are being impaired, and they have signed up to a deal such that the day the case is filed in court, you not only file with what I call an entry strategy, but with an exit strategy, where you file the plan of reorganization and all the appropriate papers, and you ask for a very accelerated timeline to exit the bankruptcy. That's prearranged. Now, there are all sorts of varieties and flavors of prearranged. I call them, there's real prearranged, there's pseudo prearranged, there's fake prearranged, which debtor files with a nice press release, but it may not really be completely prearranged, and there's a little bit of a hope and a prayer. And so there's a lot of room on the continuum for exactly what we mean by prearranged. There's not as much room for prepackaged, because that means you do need to have the vote pre-filing. So I'll stop there and let Sonya go.
So I also guess from, and you answered that in a way also in your comments, that there isn't really a straight-jacketed kind of a format for it, and whether it is pre-arranged or pre-packed, depending on what the industry is, where you're filing, who the stakeholders are, you would customize it accordingly. Would that be the right way to understand it, Jimmy?
Yes, very much so. And some companies and whatever their problems are very appropriate for a pre-pack, mostly if you need to adjust, say, bonds or bank debt. But if you have litigation that needs to be resolved, or you need to deal with lots of trade creditors, it's very hard to do pre-packs. And so that makes it more difficult. They are doable, and we have done them, but it's much more difficult. So the typical pre-pack or pre-arranged is where you're dealing with the funded debt, the bank debt or the bond debt. I realize I didn't answer your other question. Is it the same across the United States? It's the exact same rules across the United States, but because it's not really in the statute, it's been custom and practice is how it's grown up. Some courts are more accepting of pre-packs and pre-arranged than others, especially accelerated ones. But it's the exact same. It's supposed to be the same across the country, but sometimes it's not even the same across the hall.
Well, thank you so much, Jamie, and I think that's very helpful. Let me just go to you, Sonya. I mean, I have the same question for you, which I asked Jamie. How do you, in UK, understand the pre-pack? And also, is there something called pre-arranged plans as well there, or is just a pre-pack? And how do they fit into the framework whether they're part of the law or they operate outside. So almost the same question, but looking at it from the prism of UK.
Yeah, thanks, Sumant, and thanks very much for inviting me to speak on this panel. It's a really important topic for India and the rest of the world. Well, in the UK, it sounds like it's a similar situation to what it is in the US. There's no statutory definition of pre-pack. So when you ask me as an English insolvency lawyer, what is a pre-pack? I would say that it's a pre-pack sale, which happens in the context of an insolvency process. And it involves the sale of the assets of the company to a person, and that sale can be free and clear of all liabilities of the company. Now, I don't think that that's precisely on point for your Indian pre-pack process. I think that what would be more on point in terms of our processes over here is a scheme of arrangement or a plan of reorganization, which is a compromise of claims which a company proposes to its creditors or a class of its creditors or several classes of its creditors, and those creditors vote on the compromise, yes or no. And depending on which route you go down, whether it's a scheme on the one hand or our recently implemented plan of reorganization on the other hand, you can or cannot cram down a class or classes of creditor within the plan. So on our most recent plan of reorganization, it is possible to impose the plan on classes of creditors who do not agree to it. So that's sort of vertical as well as horizontal forcing of the plan. So just to sort of elaborate a little bit on the process and of the scheme and the plan of reorganization. Now, interestingly, they don't need to be done within an insolvency process. So it's a debtor in possession process in the sense that the directors of the company usually drive the compromise, the terms of the compromise, but they very often do it in connection with a negotiation with a small class of the creditors who help them to negotiate the specifics of the plan and give them a degree of confidence that the plan will be approved when it comes to vote. Now, there is also a light touch court involvement on our scheme and plan of reorganization. Two points where the court gets involved. The first is to convene the meetings, to order the convening of the classes meeting. And there they decide on whether or not the classes have been properly comprised. And then the classes go to the meeting and they can raise questions there. And then the second time that the court gets involved is if the classes have voted on the meeting in favor of it, then the court will decide whether or not the plan should be sanctioned. And if they do decide that the plan should be sanctioned, then the claims of those involved will be compromised in accordance with the terms. So yeah, I would say that there's sort of, in our world, there's sort of three things that you can imagine as being a pre-pack, if you like, quote unquote. The first is what we regard as the pre-pack administration, which I mentioned firstly, which is a true insolvency process. But ironically, there may not be any court involvement in that, and I can talk about that in a bit more detail later. And then the other two are our scheme of arrangement and our plan of reorganization, which are Companies Act beasts. So they are beasts of our Companies Act, not beasts of our Insolvency Act. Perhaps that gives you a sufficient flavor for the different kinds of processes that we have, which I think are most on point with the Indian proposals here?
Well, thank you so much. I know I'm tempted to ask you a lot more questions out of what you just mentioned, in particular about the sale, pre-pack sale part, but that may not really fit into the Indian context at this point in time, because I think the focus here is quite clearly the turnaround, the achievement insolvency resolution through the pre-pack, and of course I'm sure as a part of the pre-pack scheme, the stakeholders could propose part of the assets to be offloaded in order to facilitate the turnaround and reduce the burden of the cost burden, et cetera, or otherwise restructuring. But I don't think that's really the goal. But we may come back to that in a moment, in a different context. I actually would like to deep dive a little bit here now in terms of trying to understand from the perspective as to which will be very directly relevant. And I think, and from that perspective, let me just go back to Kevin at this point in time. One thing is, there are two questions that I'm going to ask you, Kevin, and they may not be directly connected, but they ultimately the dots hanging around would eventually connect at the bottom. One is that are the pre-packs available to all the kind of enterprises, or at least in terms of how they're prevalent or how they're used? Is there any particular set of industry or enterprise that use that? That's more of a general question for us to understand, what kind of companies prefer it, public, private, manufacturing, service provider, we don't know. I mean, just one comment on that. And second is where the deep diving happens. Who are the key stakeholders in the pre-pack, or be it the pre-arranged? Because I see that they're only, in a way, two different sides of the same coin in some way. So my second question, just to repeat, would be, who are the key stakeholders who need to be engaged necessarily in order for the plan that is proposed to earn confidence, invite confidence of the larger stakeholders who are not engaged, and get this comfort that this has been driven by the right people, and we can believe the disclosures, as Jimmy mentioned, ought to be provided. So these two questions, and then there may be some follow-up questions which I may have based on what your observations are.
Sumant, thanks for having me. Look, I would say that starting at a high level, private or closely held corporations are easier to move through a pre-pack than a public one, as Jamie said. You could have public companies as well, but it's easier when you have fewer stakeholders. So what would a capital structure look like to ease a company through a pre-pack? You'd have one or two tranches of secured debt. You might have an unsecured bondholder class. The equity would be held by, a handful of private equity or hedge funds who might also own parts of debt tranches. But I guess the short answer is the fewer stakeholders there are, the better. And there are different ways of easing a pre-pack through. For example, many pre-packs simply provide that trade gets continued to be paid, even though the bankruptcy is initiated, and even though there would be a stay which would normally prevent creditor recoveries. And it's not enterprise or industry specific. I think any industry is apt to be able to take advantage, an enterprise in any industry, of a US pre-pack. So again, having fewer stakeholders like secured creditors, and those, you reach out either expecting a default to occur, or one having already occurred. The company may have already been in a series of forbearance agreements with its secured parties. I also find that if there's no argument or dispute about valuation, that helps add to the efficacy of a pre-pack. Best organized, best planned, that's what gets you through. To follow up, one of Jamie's points is, there are pre-packs that are presented as pre-packs but are really only partially packed, and they're really prearranged. There are some that hope that once the bankruptcy Chapter 11 is initiated, that those who had not yet agreed would jump on board, figuring better to get on the train before it passes you by. So there are all manner of pre-packs and prearranged, and I hope that answers both your questions.
No, you did. Thank you so much. What I take away from that, obviously the pre-pack is more effective. It doesn't really have too wide a spectrum in terms of stakeholders and complexities of capital structure, loans, and everything, because that would only mean more stakeholders and more engagement and more uncertainty. So I take that point, and I think to that extent, that is something which also reflects as a thinking in the context, especially in terms of taking the baby steps forward. Because at the end of the day, we're going to just touch our feet into the cold waters and make sure that there's something which we are willing to swim in. And I don't think we are taking a huge leap of faith, at least for the moment, and especially because there have been very mixed experiences from around the world on pre-packs, and it's not really been a very exciting world. So one wouldn't really say that we've got to do this come what may, because we want to be sitting on the center stage of the economy or the global stage of the insolvency world in terms of all the tick boxes. But so let me ask you one more question, Kevin, and then I'd like to ask the same question also from Sonya before I go to Jamie, which is the transparency part. Although I know Jamie touched on that a little bit in terms of the disclosures, but are they, in terms of the judicial precedents and how the market dynamics have worked in the past, are there certain do's which you just can't do away with in terms of the transparency? Because unless you have the market confidence on this, how do you sustain? Because there'll always be a degree of suspicion in terms of what happened behind the scene, because this is not really happening on the stage out there where there's so many observers, participants. Don't you think so? So how would you respond to that?
Well, that's a great question for a former U.S. bankruptcy judge. In a pre-pack, a bankruptcy judge may be presented literally in the first couple days of the case with what the parties want to be considered a fait accompli. So transparency, and it's consistent with Indian policies and principles, is paramount. As Jamie indicated, notice to parties, due process, especially in the U.S. courts, is heavily considered. And what the judge doesn't want to hear is that there was an important stakeholder who was not invited to the table to participate in coming to an agreement, either as part of a pre-pack or a prearranged plan. And part of that issue is the timing. How quickly do the group that's agreed on a plan want it to be confirmed? And so the shorter the timing, the greater the scrutiny a judge is likely to view a pre-pack with.
Well, thank you. Yeah, Kevin, maybe before I go to Sonya, then Jamie, I should ask you one question that just sort of struck me as Kevin was speaking, was on what is the standard length of notice to creditors and others that is expected? I mean, is there because you said this is not in the law or in the rules as such, which are part of the statute, then is there a standard notice period that is expected, and how long does it take? I know you mentioned it very, very briefly, but could you just amplify that on a little bit?
Yeah, so one thing that is in the rules is a notice period, and in the US rules it's 25 days notice, unless a judge could change it. But when you're doing a pre-pack, there's no judge, so you would change that timing to shorter at your peril, because you'd have to get a judge to approve it later on. So almost all pre-packs, you would do 25 days, and then you want to be safe with timing for mail and et cetera, et cetera. So you're probably doing 30 to 45 days, assuming that the company has enough time. Same thing generally in a prearranged, except you're not doing the vote, so you don't have that kind of notice issue. And the thing about when I say it's not in the statute, when you're doing a pre-pack, you actually just look at the statute and the rules that apply to any regular bankruptcy case, and you do everything you can to comply with all of those, even though you're not in bankruptcy yet. So when you do show up before, at the time, Judge Carey or other judges, you say, this is what the code requires, this is what you would have ordered me to do, and I already did it. And I did it well, and I dotted every T and crossed every I'm sorry, dotted every I and crossed every T. So that's that timing. Now, if you're the biggest timing of all is to cut the deal. And I can't give you a timeline for that because that could take a day or a week or a month or 6 months. But once you cut the deal and you're presumably preparing all the documents while you're getting the deal cut, the timeline for a pre-pack, as I said, probably 30 to 45 days before you file. And then once you file, maybe another 30 to 45 days, except I think we'll come to the super accelerated pre-packs before the day's out, where you can do them even in 1 day. But maybe it's the technical process from start to finish, from sending the voting documents out to when the judge approves it all. You could do it very comfortably in 60 days, 90 days for sure, and a lot shorter than 60 days in other circumstances. Prearranged take about the same amount of time, but you don't use that 45 days voting period out of court. You do it in court.
Yeah, well, that's fantastic. I mean, 60 to 90 days, and you said the norm is 60 days, and it could take 90 days. Though. And did I hear you right? You said 1 day. That has there been a case where it's been done in 1 day?
Yeah. So without tooting our horn too much, my firm has done 4 of those in the past couple of years, and in fact, we have another one we're doing next week. Call them 24-hour pre-packs. There's a little bit of controversy surrounding them, not because they violate anything. It just almost like you just reacted. It seems unbelievable. It's incredibly fast, but it's actually using the exact same toolkit I just talked about, but accelerating it down to 1 day. And, we talked internally at my firm ways back and said, why can't you do this in 1 day? As long as you give the 25-day notice, and we're very careful in making sure that's really 30 to 45 days. You have to send out all the motions in advance, all the pieces of paper of what the plan and disclosure statement is, all of the, what we call a plan supplement, everything that the reorganized company, the credit agreement, the bond indenture, the governance documents. And you actually let the judges' chambers know, and our U.S. trustee, which is our regulator, all know way in advance and provide them all of the papers. And you actually get a date for when the hearing will be on the day you file. And you just do everything at once. If somebody shows up and objects, either says notice wasn't good enough or I have a substantive problem, you're not going to get it done in 24 hours. But if everybody shows up and there's massive buy-in, you have 95% of creditors agreeing, and you have a multiple stakeholders saying to the judge, this is really good for the business to be in and out of the bankruptcy so quickly. It's actually doable. Not in every case, but it's doable.
Well, that's almost unbelievable. And Kevin, I'm going to ask your experience of that in a moment. But let me just go to Sonya for a moment, because I wanted to ask the same question to you, Sonya, as well. One on especially because when you said that, there's a very little touch of the courts in the pre-packs, and therefore it doesn't really become all the more, necessary that there are rules of transparency and there is greater confidence of the stakeholders. And how does that happen then? And also, if you could then also touch briefly upon how much time does it take in the UK context? So essentially 2 questions.
Yes, so you're exactly right, Sumant. The transparency requirements have really grown up through practice and through case law. So, we know how much transparency and what kind of transparency is required by those 2 means. And basically, it's satisfied by a combination of measures. One is that there needs to be a fairly detailed explanatory statement, which is sent to everybody who's invited to vote on the plan. And that explanatory statement, it usually is a very long document, actually, and very detailed. And it's been described as disclosing that information that is necessary to enable a reader to determine how to vote on the plan, yes or no. And they need to disclose directors' interests. It needs to disclose what the relevant alternative would be in the absence of the scheme or the compromise, so that people know, that they're comparing apples against apples. I'm being asked to vote on this, but what would happen if if we didn't vote on this? What would happen if, in the absence of this scheme? So that's one safeguard. The other safeguard, as I said, is the the 2 times court processes, where there is a level of scrutiny about the process, and the court will examine the explanatory statement. It will examine the length of time that creditors have been given to consider the process, and usually it's about 21 days would be the minimum time that notice would be given to creditors. And at the meeting, in terms of transparency, at the creditors meeting, creditors are entitled to raise questions, and that's an important process that creditors need to be mindful of exercising their rights at. I mean, especially those creditors who have not been involved in the lockup, the COCOM, negotiating the plan with the company. And then at the second court hearing, the sanctioning the plan, that the court exercises a degree of scrutiny about whether or not it's reasonable to approve the plan, and whether or not each class has been fairly represented, and whether or not they're actually exercising their voting bona fide for the benefit of the class. That's a very old rule of equity in our law that is applied here. So I think that's about it in terms of the transparency. And yes, as I said, it's all grown up through practice directions and case law. And in terms of time, from beginning to end, as Jamie said, once you've cut the deal, which could take anywhere between, a week and 6 months or longer, it would be about 90 days from go to woe, from giving the notice, the 21 days notice to the sanction by the court. It could be quicker, but rarely so, and we could never do it in one day. A 1-day pre-pack is the pre-pack that I mentioned at the beginning when I first described what we know as a pre-pack, and a true pre-pack is done in 1 day, and the sale of the business is done on the day that the administrator, the insolvency practitioner, is appointed, and he or she will conduct the sale.
Well, thank you, Sonya. I mean, I think this is very useful in terms of the part with regard to the explanations, and also what you mentioned about the other safeguards, and of course the jurisprudence. That of course does guide a lot in the Indian context. Although of course some of the fundamental principles, obviously we also see guidance from the jurisprudence that has developed over a period of time. That's what the experience has been. But in the insolvency process, the Supreme Court has really set down its own rules. I'm talking about the Indian Supreme Court, and which has obviously been in the Indian context, but it is the liquidation, and I know I'm speaking a little out of the context here, but in the liquidation process is something which we do believe that the jurisprudence from abroad is going to come in very useful. And although I know Justice Ramesh didn't really mention about the liquidation, and he had exchanged notes and we had spoken about these topics at length, but one of the areas on which I think III might be able to help also is the liquidation part, because we are entering into a phase where there are a lot of liquidation companies go into liquidation, and also there are a lot of voluntary liquidation companies as well. And we'd like to understand a little bit from the experience of the other countries as well on that. But again, that's a separate question. We'll come back to that in a moment. I'm now trying to sort of go back to the discussion that we were having. And actually that really, underlines the importance of disclosure. And I have a question actually from for Jamie from Tim Desenio, which is more of a comment rather than a question, and then also from Anuradha Malik about the safeguards, part of it which has been answered by Sonya, but maybe this is something which I can go to Kevin again on the 2 points, just to complete the discussion on the disclosures, the importance of disclosures, and from a judge's perspective, do you look at it microscopically, or do you just look at it only if there are complaints? If there is somebody who comes forward and says, I've been given notice, but I'm not satisfied with the disclosure. I need more explanations. I need, or there are any standard expectations. So a little bit of from your perspective on the disclosures, and in the event you find something as unsatisfactory or incomplete, would you then ask the propounder of the scheme to come forward and provide disclosures which are to the satisfaction of the parties concerned and of course the judge? That is one question that I had. And also, I mean, in terms of the time frame, I mean, realistically speaking, do you think that this is something which is doable in as short a period of time as 15, 30, 40 days, or even 1 day as a norm, or 1 day is really an exception? That was more of the lighter side, if I can say.
So let me answer your second question first. Before, I think the 1 day pre-pack came into vogue, I had an experience in a case I was handling called the Tribune Company. They were basically a newspaper and media company, very large, but they also owned a baseball team in Jamie's hometown, the Chicago Cubs. So the Tribune entities filed the Chapter 11, and we were well into the 11. And the company then said, okay, we'd like to sell our interest in the Cubs, in the baseball team. And that involved, I don't know, 2 or 3 or 4 entities that had interest in the Cubs. But they said, what we'd like to do is give notice of the sale before we file the Chapter 11s, and under which we would conduct the sale. And I said, okay, make sure you give all the appropriate notice to all the appropriate creditors or other stakeholders. And I think the sale hearing was held just a couple of days after the filing. It's been long enough ago that I don't remember specifically, but there were no objections and I approved the sale. So I do think it's possible, as Jamie said, if you follow the procedures that would otherwise have been followed in the bankruptcy, you've really, maybe not completely insulated, but mostly insulated, at least the due process issues from contention. To the first issue, look, disclosure on a pre-pack, the judge knows absolutely nothing about the case or the history except what the parties tell the court in filings. And it's virtually impossible, to your other part of the question, that unless someone stands up and raises their hand and says, there's a flaw here in what the company and its allies have done, and it needs to be corrected. Now, if the disclosure has to be supplemented, then the judge has to decide, is it such a disclosure that would require revoting, or doesn't it? So that's another challenge that both the parties and the court has to work their way through.
Can I add something, Sumant?
I'm sorry, Jamie, I was mute. My apology. I'm going to ask one brief question to Kevin, and then I'm going to come to you. I wanted to ask Kevin, I mean, more specifically, so are you saying that the judge would have discretion to disallow the scheme as proposed, or to ask for amendments in the event he's not convinced, basis the objections, the validity thereof? And also direct a revote? I mean, that would fall within the discretion, right, of the judge. Is that the understanding?
So the statute is specific about what standards must be met with respect to disclosure. It's called adequate information, which means different things for different types of creditors. And it has confirmation standards, and both must be met. And even absent objection, the law is pretty much uniform through case decisions, that the bankruptcy judge, even in the absence of objection, has the independent responsibility to make sure that each of the both disclosure and confirmation standards have been met. So I guess, yes, it does give the court, although there are standards in the statute, gives the court a great deal of discretion to decide whether both standards have been met.
Well, thank you so much. That's very helpful, because this is something I think is very, very relevant to the Indian context, because we really have to build something which is sustainable and something which really earns the confidence of the market. I think some of these observations that you made are really very, very helpful in trying to understand. Jamie, over to you. You want to say something, and then of course I have a question of my own to you as well.
Okay. I was just going to add 2 or 3 quick things on what Kevin said. When you're doing a pre-pack or even a pre-arranged, it's no time for counsel to be aggressive on timing or questions of, do I need to disclose this or not? We always say, if you're debating whether you need to disclose it, disclose it. And because you don't want to show up and have Judge Carey, when he had the robe on, or other judges, and say, you know, it's too bad you didn't do this because I would have been comfortable otherwise. If it's a close call, and even if it's not a close call, disclose it. If you got to take 5 more days, take the 5 more days of proper notice. So you do that. And the other thing is, I would say, you know, India is a big country. The US is a pretty big country. The number of professionals actually doing this and appearing in front of the various judges is amazingly not that many. And I think there is a credibility factor of some comfort factor with the judge of, you know, our people are going to be back before me again. And so if they're telling me this is done right, you know, the judge has to do all his work, but you come in with some credibility if you've been there before. And then the other thing I'd say, interestingly, I think different than what we're hearing happens in the UK, it's a rare pre-pack or pre-arrange that involves a sale. In the US, most of them are actually reorganizations where the creditors may take control, but we generally don't use them as a sale process like Kevin just described for the Chicago Cubs, who I'm a big fan of. But I actually, as I think about it, don't see why we couldn't do that. Sale processes involve a lot of twists and turns, so it's even more complex, but there's a lot of room for creativity there. But historically in the US, it's been much more reorganization amongst the stakeholders already at the table rather than a sale.
Well, okay. The question that I had actually also fits in quite well into the discussion that we were just having. It sort of dovetails into the larger transparency disclosure discussion. And in the event it is found that there was indeed a fraud or an intent to mislead and do something which is dishonest, are there any penal consequences which would serve as a deterrent for others to do anything similar?
Absolutely. Jail is one of them. And loss of your legal license is another. As if not more important, I just talked about credibility. That's the last time, not just with whatever judge you appeared before, but any other judge that you'll be able to get anything done, even if you don't go to jail or lose your license. So there's, in my view, massive deterrent for improper conduct. You know, there are clients who want to push the envelope, and it's the job of counsel. Sometimes I say is the hardest job of all is with your own clients sometimes, is to do what's right and present what's right before the judge. So I think there's you know, tremendous deterrence built into the system.
Well, thank you, Jamie. And I hope this answers a question that Anuradha Malik had posted about process being abused for a purpose other than a bona fide restructuring or sale. Sonya, I mean in the English context, you know, the whole issue of you know, the process being abused or misused. I mean, had there been any instances where one would say that might have actually impacted the prospects of pre-pack growing beyond a point? Because as you mentioned that the pre-packs are prevalent and they're quite in use, but there are other processes as well, and people tend to use others as well as much as they would use pre-pack. And is there a particular reason for that, or have been instances of fraud? And do you think that this would attract severe penalties in UK as well?
Just to pick up on a point that Jamie noted about what I was saying, in terms of what our pre-packs endeavour to achieve, our scheme of arrangement and plan of reorganisation don't usually involve a sale. Those processes usually involve a compromise of creditors' claims, and the scheme of arrangement usually is limited to financial creditors. The plan of reorganisation is a broader based balance sheet reorganisation, which can include non-financial creditors as well in separate classes. So I just wanted to make that clear, that the pre-pack, as we call it over here, is almost by definition a sale, which happens on the going into of insolvency. But to answer your precise question now, Sumant, in terms of you know, due process, yes, there have been instances where I would say perhaps fraud, perhaps lesser bad behavior than fraud has come to light. A creditor or a person in interest has brought that to the attention of the court, and that the scheme, which may have actually been passed by that the creditors invited to vote on the scheme, has not been sanctioned by the court for that very reason. And we have had a couple of cases where that has happened. And in terms of recourse to those, the perpetrators of the misconduct, certainly, directors can be disqualified. There can be jail, there can be fines. So there is, I would say, due process there. And I think just to go back to what we call the pre-pack, which is, the sale on day one, that is the process that has given rise to the most controversy, because it usually happens outside of the court supervision. It happens by an administrator agreeing the sale on day one, and it happens without the involvement of any unsecured creditors. So the unsecured creditors wake up one day to find that the company against whom they have a claim has had all of their assets sold, and they now have a claim against an empty company. And very often the complaint is that the sale has been made to a connected person of the company. So the old directors of the company have bought the assets and have sort of cleansed the business of the unsecured claims. So I would say that process has given rise to the most rigor in terms of practice requirements, and the Parliament is forever developing ways to address these concerns.
I'm so sorry, I keep forgetting that I am muted. So do you think that there are any prospects or possibilities of the Parliament actually legislating on it and trying to convert it into a formal framework? Because pre-packs are efficient, they're speedy, but you need to provide safeguards, and some of them that you mentioned as concerns of sale on day one by the administrator outside the court, unsecured creditors left just as spectators, and the companies being sold to the related parties at a price which may not really be the market price, and all these transactions. So do you think that in order to curb these some protection in law through a formal framework, do you think that's a possibility in the UK, or you think that this probably is not going anywhere as far as the formal framework is concerned?
I think it's going to continue to be a process of practice statements and best practice, which is written down and keeps evolving, and we continue to have government reviews of the process. And in fact, the latest government review of the process addresses the concerns given rise to sales to connected parties. And one of the recommendations is that the connected party needs to provide an opinion given by an independent person that the case is made for the price that's been paid and the transaction itself, that there needs to be a case made. And I think the overriding principle of a pre-pack, so-called, is that the administration, which is conducted within, needs to be for the benefit of the creditors as a whole. And I think that is the guiding line which drives our regulation. But in terms of this being sort of within the law, yes, it's within the law in terms of practice statements, and it requires justification if you sort of deviate from the best practice. You need to explain why you're deviating from the best practice. And yes, it will go before a judge, and the judge will decide if it's complained against by the unsecured creditors.
Right, thank you. Well, I've just got one last question for you both, Kevin and Jamie. Kevin, for you, do you think that the US might also consider taking it and enveloping it into a more formal process than as it is at the moment? I know you mentioned that there are rules and everything, but do you think that there might be a time in future where you also want me to give it a formal legislative framework?
That's a great question. The problem with amending the bankruptcy code is that once the door is opened in Congress for discussion about changes to be made, lots of interest groups and parties have a view about parts of the statute that should be changed. So having said that, I will say recently in connection with the pandemic relief, some amendments were made. And just before that happened, some small business amendments were made. But I would be surprised, put it this way, if there were legislative appetite for a change of that nature. It would come if there were a class of creditors or interest groups who felt that they were being disserved by use of the pre-pack. And I don't presently have a sense that there is a group, perhaps other than equity, which might complain about it, but equity gets abused pretty much in every Chapter 11. So that would be nothing new.
Okay, thank you. Jimmy, my last question to you, the panel actually is to you. Then I had a couple of questions which I'd like to articulate into one because we don't really have much time. Is that between the Chapter 11 or a formal insolvency process and pre-pack, which do you think is the most efficient or the preferred in the context of US from a stakeholder's perspective?
Yeah, it's a good question. I was sitting here thinking about that as listening to all of the other panelists, and there's actually a real trade-off because it depends how you define efficient. The pre-pack, especially the 24-hour one, but any kind of pre-pack or pre-arranged has the massive advantage of getting a company in and out of what I call the car wash, in and out of the formal court proceeding as quick as possible. And generally, that's a good thing. Having said that, there are some companies that need to spend more time in the car wash than others. And what I have observed over a lot of years in looking at a lot of pre-packs and pre-arranged is you sort of end up with what I call a suboptimal capital structure because what it takes to gain the efficiency of speed is significant buy-in of all of the stakeholder groups. And to get that significant buy-in, obviously takes compromise. And that compromise ends up with a capital structure that is not always fully fixed. And so you're compromising speed and getting in and out of bankruptcy really quick for a capital structure that might be 75 to 80% fixed instead of all fixed. So if you do a regular Chapter 11, what we call a free fall, and you take a year or two and you do a lot of the hard work of rejiggering the assets and getting rid of leases and improving operations and ending up with an optimal capital structure, you could argue that in quote marks that that's more efficient. Now the professional fee costs of that are skyrocketing more than the pre-pack and pre-arranged and the potential damage to the business of being in a bankruptcy for a long period of time. It's usually, the question usually answers itself because as we talked at the outset, some companies just are not made for pre-packs or pre-arranged because they have significant operational issues, and others are tailor-made for it if you just need to adjust the bond and bank debt. There is a little bit in our, we obviously have a lot of secondary buyers of hedge funds and the like in the US Chapter 11s now or US restructuring community. And that does drive a need, at least in their minds, and this is not a pejorative, for IRR. And IRR is very time tested. And so they have a huge bias for speed, even if you end up in a potential, what we call Chapter 22, if you have to do it again in a couple of years. And that doesn't mean you failed. It means you didn't fix it all the way, and maybe the second time through you fix it. So that's unfortunately a little longer answer than you'd like, but it's a real philosophical issue.
That was very helpful, Jamie. And this was a question that actually came from the audience. A gentleman, Satyam Podar, asked that question. So, and I hope that he would be happy that his question has been answered.
Well,
There's
that's an
one
interesting feature of the
Please.
proposed pre-pack in India. There's a 3-year period of time
monitoring.
in which
Yeah,
you
cooling
cannot go
period.
back for pre-pack.
Cooling period, yes, yeah. Yeah, that's right. Yeah, I mean, of course, there's going to be a lot of experimentation in India as well, because we have to go back to see what our past experiences have been. And one of the concerns, of course, would be, I mean, and of course, there are a number of concerns, but the 3 that I would see from my perspective would be 1, how to maintain transparency, 2, stakeholder engagement, and 3, of course, how to prevent the abuse of the process in terms of, trying, although, of course, there are a lot of things that will stem out from these, but these are important to sustain any new thing that you're doing, because a huge market, we have had some bad experience in the past, and we want to make sure that whatever we do has the market confidence and is sustainable. There's one more question from Mr. Vora on the frauds lessons for India. In addition to laws, what more can be done? And I think a lot of that has been answered by Sonya and also by Jamie and Kevin, or from the point of view of disclosures, the safeguards, the discretion of the judges, and a number of other measures, the explanation statements, the jurisprudence. And I think if you package them together, they would form a good combination to address the concerns. I would have loved to ask one question to Justice Kannan. I know, I mean, but maybe, I don't want to sort of take him by surprise, but I know that Singapore actually did approve a pre-pack scheme. I think about 2 weeks back, maybe even earlier. I just read a flash in DRR somewhere. I haven't read the detailed judgment. I know we're running out of time, but if 2 minutes, Justice Ramesh, if you just 2-3 minutes, we'd like to talk about that. Now, not as much about the details of the judgment, but generally about Singapore approach to pre-pack.
Yes, well, we have legislated. We have got introduced Section 71 of the Insolvency, Restructuring and Dissolution Act in 2018, which provides fairly great detail, great detail that requirements that need to be satisfied before a pre-pack is sanctioned by the court. And in terms of disclosure, the disclosure regime is no different from what needs to be set out in an explanatory statement for a court-ordered scheme meeting. The specific language of Section 71(3) of the Act is that the disclosure statement must contain information concerning the company's property, assets, business activities, financial conditions, and prospects, information on the manner in which the terms of the compromise arrangement will, if it takes effect, affect the rights of the creditors. And then there's a catch-all which says, such other information as is necessary to enable the creditors to make an informed decision whether to agree to that compromise or arrangement. There are also provisions which require directors and trustees to disclose information if required by the creditors, and if they don't, then they're punished by, it's actually an offense under the Act. And I go back to what Jamie is saying. Jamie said about disclosure being key. There is case law in the UK, and which again is echoed in case law in Singapore by the Court of Appeal. Disclosure is extremely important in a pre-pack, in a scheme, whether it's in the form of a pre-pack or otherwise. And so consequently, if in doubt, disclose. If there's inadequate disclosure, the judge feels that a disclosure is material, the shortcoming disclosure is material, the scheme will not be sanctioned, and therefore you're back to ground zero. What we have done also in relation to COVID was we took the pre-pack regime, modified it, and introduced a 120-day restructuring program with an appointed officer who works like a mediator to restructure, to organize pre-packs for SMEs. And SMEs are defined as companies within which have turnover not more than X under statute. So that's a modification of the pre-pack regime with regard to SMEs within a window of 120 days with the appointment under statute of an officer who works like a mediator to work out the plan. But that's a single class restructuring, and we're in that process. We have adjusted the thresholds for voting. So that's what we have done. But we have passed legislation to provide for the pre-pack. So
thank you so much. That's very helpful. And I know I'm sure in another occasion we will probably have a deeper discussion on Singapore and also some of the issues that was discussed today, and probably on a different platform, and probably in a much more closer discussion with the IBBI going forward. And we just have 2 minutes, and I want to use these 2 minutes to thank all of those who of course are here on the panel: Jamie, Kevin, Sonya, and Justice Khan, Ramesh, Dr. Sao. Thank you so much. I know it was very odd times, early mornings or late evenings for you, and I really appreciate for you all taking time and sharing your experiences and observations. And I can assure you that they would be very, very helpful for all those who were tuned in. I also want to thank, of course, Anika, Shari, and Kuman. We had some preliminary discussions on this before to make it happen. And they are very efficient, very patient. I have always joined at the last minute, but they welcomed me with a smile, but and not just panicked. Which this is something which I learned from Jamie, if I may say. But he's a great friend, and I can joke with him a little bit. So thank you so much, and thank you, of course, all the listeners. There were plenty of them I saw, and of course the questions. And what a great start to the first III event in the India III partnership. And I'm sure we'll have many, many more going forward. And we'll continue the discussion with Dr. Sahoo on a more formal level from III in terms of what we can do going forward. So shall I just wrap it up, or Shari, you have any announcement or anything to do, or should I just say goodbye from here?
No, thank you all very much.
Yeah. All right, thanks so much. Have a good day or a good evening, as the case may be. Once again, thank you.